Hi, everyone. My name is Kaylee Ober. I'm the Senior Advocate and Program Manager of the Climate Displacement Program at Refugees International. I'm happy to welcome you today to ABA's event on climate change and the impacts on U.S. immigration and asylum law. I'll be playing the dual role of moderator and panelist, and I'm very pleased to have two distinguished co-panelists to join me today on this panel. We have my colleagues, both Elena Olea, who's the Associate Director for Programs at Alianza Americas. She's an international human rights lawyer with advocacy and litigation experience before intergovernmental bodies and governmental agencies. Elena is an attorney authorized to practice law in Colombia with an LLM from the University of Notre Dame, and she has over 12 years of teaching and research experience on human rights, migration, refugees, and gender. She's joined by my colleague, Bill Freilich. Bill Freilich is the director of the Refugee and Migrant Rights Division at Human Rights Watch, where he monitors, investigates, and documents human rights abuses against refugees, asylum seekers, and internally displaced persons, and advocates for the rights and humanitarian needs of all categories of forcibly displaced persons around the world. Before joining Human Rights Watch, Bill directed Amnesty International USA's refugee program and the U.S. Committee for Refugees, where he served for 18 years. So thank you both for joining. Today on our agenda, I will give a kind of a 30,000-foot view intro to the topic of climate change and migration. My colleague Elena will do a deep dive on the regional dynamics happening in North and Central America. And Bill will talk a little bit more about kind of international frameworks and law, as well as US immigration and asylum law and ways forward based on our conversation. And then we'll have a moment of Q&A for the group. And just a reminder to please enter your questions in the chat, and we'll call on you as we enter into the Q&A session. So with that, I'll turn the floor over to myself, I guess, and give this mini presentation that gives kind of an overarching view of the issue of climate change, migration, and displacement. First, I wanted to start with something I think we all know very well, and that is climate change is not a future event. We are all in the midst of a climate crisis. In fact, this is already influencing different migration and displacement dynamics and trends around the world. For instance, the Internal Displacement Monitoring Center just released their annual internal displacement report, which finds that in 2020, around 30 million people were internally displaced by weather-related disasters, or 3 times more than the amount of people displaced by conflict. You know, this is an astounding amount. But just to say that there are hotspots according to this data, for instance, South Asia and East Asia and the Pacific make up more than half of this displacement. And this is just a note that this displacement is due to sudden onset events largely. And the Internal Displacement Monitoring Center and others do not have good data or methodology yet to really understand and record numbers of people displaced by a variety of slow onset events. So here we see some of the limitations about accounting for the number of people displaced or at risk of displacement due to climate change or in the context of climate change. And we must always be careful about numbers. In fact, decisions to migrate are complex and multi-causal. It's based on highly contextual factors, often determined by complex interactions at the site of disaster or the environmental change, including the underlying vulnerability of people and communities, the magnitude and frequency of the given climate-related hazard, and the ability to cope with such events. Climate change is rarely the only factor that makes an individual decide to move. However, it can exacerbate existing conditions or vulnerabilities that underpin principal drivers, which are often political, economic, or social in nature. Despite this, we often try to determine future projections of people who might be displaced or forced to migrate in the context of climate change. We do so because it's helpful to understand risk and patterns of movement, but we always must put those into the context at which those projections are being made. You know, for example, I worked on a report with the World Bank called Groundswell on internal migration in 3 regions of the world up to 2050. Often the number that's most well known and thrown around is more than 140 million people migrating internally by 2050 in those 3 regions. However, that's just one number provided in the report. It's based on a middle of the road scenario with some mitigation measures taken, some uneven development growth going into the future, and it's not meant to be a number set in stone. It's purposely based on scenarios and meant to help policymakers conceptualize the difference between different policy decisions they can make today. For instance, deep cuts in emission, just transitions, including climate change adaptation and resilience, increased social protection, reduce the number of people migrating in the context of climate change by 50 to 80%. And what we want to know, aside from numbers, is kind of the more qualitative things behind who might be migrating in the face of climate change. You know, again, it's very contextual, it's multi-causal, but we do know a few things based on the literature. One, we know the poor will be the first to move, often because they face debilitating shocks to their incomes, often as they have livelihoods that are more dependent on rain-fed agriculture. They may turn to seasonal migration to weather these kinds of lean seasons, or in some cases, they may need to move permanently. Most of this migration will be rural to urban in nature, as people seek out better, more stable economic opportunities not tied to the weather. You know, and we should note that it takes assets and capabilities to migrate. So the poorest of the poor may end up becoming trapped. If and when people cross borders, it will likely be to neighboring countries or along well-worn historical routes made by relatives or their compatriots before them. This is less likely, though. There will be no hordes crossing borders, despite what some of the media headlines might say. So, you know, to target policy based on this, to understand how to enable international frameworks or regional frameworks to really support those who might be affected by climate change is complex. You know, first of all policy should be based on the desires of people that are facing those effects on the front lines and support them to adapt in place if they would like to do so. However, some people will need to move, and they must be given the opportunity and choice to do so. In fact, we shouldn't fear migration. It's a legitimate form of adaptation in some cases. So with that in mind, policy should not just be about stopping migration, but ensuring that this policy ensures that this movement isn't under duress and is in fact safe and dignified. So, you know, these are important things to keep in mind, especially as we have some new policy opportunities on the immediate horizon, including a February 4th executive order released by the Biden administration around climate change, preparing for climate change and migration. In section 6 of that executive order, President Biden requests a report to be delivered in 180 days on the issue of climate change and migration and its impact on different types of policy, including protection and resettlement of individuals who may be displaced from climate change, including on foreign assistance, including on international security implications, and multilateral engagement processes related to this issue. So there's a huge wide range of things that can be done by the US government, and it seems to be there's an appetite for it. And so I think it's important to keep these organizing principles in mind, that we shouldn't be afraid of migration and that we need to engage with policy in a way that puts frontline communities at the center. I think my colleague Elena Olea will give us a little bit more of that context and background within the scope of North and Central America. And so I'm going to turn it to her to give us a little bit more of that context and to understand those trends and dynamics. And then we'll add some more context to that as we go. So Elena?
Kaylee, thank you very much. I would like to start by thanking the American Bar Association for the opportunity to speak here today and for their interest in a very timely and necessary topic. We definitely need to continue including climate change in our discussions because sadly, what you said, Kaylee, when you began about the fact that we are living in a crisis is something that many continue to refuse even to accept, and that many also opt to ignore because it is distressing. Of course, you wonder, what are we doing to prevent this from continuing occurring? What responses are there to climate change? So this is a very timely discussion. I am going to talk briefly about the situation in Central America, and because I think that this is a very important and has a direct impact on the United States. And unfortunately, I am afraid that there is not enough knowledge about the situation in the region. I think that one of the most important challenges that we face with climate change is the fact that in most cases, climate change is a main factor for displacement, but it is not the only factor. And that is because in the process, a number of other factors and state weaknesses and individual weaknesses and vulnerabilities are the mix of elements that force someone to decide that they have to leave their homes. So I think that this is important. I also want to underscore that in many cases, internal displacement becomes the preferred option. Some individuals may not be necessarily inclined to leave their country, but when there is no adequate state response to internal displacement, international migration becomes the only option, and individuals are forced to leave their communities and also to leave their countries to seek the livelihood and the protection that they were not able to find in their countries. And I think that this is very important to understand. Also, I also want to underscore that when individuals are fleeing, they are receiving information as they're seeking, shelter and protection en route to the United States. And when they begin to explain the factors that force them to leave their countries, there is very clear explanation that they have to be able to explain who was persecuting them if they are planning on seeking asylum in the United States. And so when questions are asked to them en route to try to explain how they can seek asylum in the United States, climate change definitely is not a reason why they can seek protection in the United States. And that's why, even though climate change may be a pressing factor, it starts to blur in the back of the reason of why someone was forced to leave their country. And that's why ultimately we are not able to track and to identify the relevance of climate change in the exodus from Central America to the United States. And I think that that's also an important element that we need to acknowledge in the difficulty to appreciate the dimension and the impact of climate change in the region. I also think it's important to underscore that in some cases, migration from one country to another is sought, and we also observe that in the region. Not all migration arrives ultimately to the United States, and a few trigger cases to Canada, but in some cases, individuals seek protection and alternatives in neighboring countries. And those are factors, in some cases, that migration has also been increasing as a result of climate change. I think it's important to consider, just as Kaylee was mentioning before, that the impact of climate change in a particular individual and a family is greatly affected by two factors. First, the own ability and resources that the person has to respond to that climate event or that slowly onset climate factor that is impacting on their life and livelihoods, and also on the state response. And so when we try to understand what is going on, we have to really understand the impact of poverty. And I'm talking specifically about a number of factors, but even the building materials of a home, the public infrastructure, the access to roads, to bridges, to electricity, to drinking water has an impact. All of those factors, understanding how climate change is occurring, and on the other hand, the state response. What is the state doing to educate communities? What possibilities are they being offered in their own countries? What options are there for adaptation? Are crucial in many communities. So in the US, for instance, we think of agricultural insurance as, something widely used as an alternative that growers have. That does not exist in Central America. If someone who has a small crop of any product loses their crop as a result of a drought or as a result of flooding, they have no insurance. There will be no state response. And I think that that's also very important to consider. So when individuals lose their livelihood, they also seek other forms of employment so that they are not forced to migrate. And when they do not find that option, that is part of the factors that force them to consider moving further away. And I think that that's really another factor that triggers international migration. So if there were more options to adaptation in countries of origin, that would definitely have an impact on migration. And I think that that's also where we need to take some of the discussion, because that does not exist. Another important factor that I mentioned before, but I do want to underscore, is that many Central American states continue even to deny that internal displacement is occurring in the country. There is also a very weak response in terms of humanitarian assistance and also of durable solutions. And that is also a main factor of displacement. And I think it's interesting also to contrast the situation in Central America, for instance, with the situation in the United States, where in the case of Colombia, where there were millions of internally displaced persons. There were over 3 million of internally displaced persons, and there was built the state capacity to respond. Probably not as good, not as a strong response as we would have wanted, but there was a response to internal displacement. We are not seeing that in Central America. That is a factor that contributes to international migration, and I think it's important to underscore it. I think another factor that I wanted to share with you is a specific story that I think illustrates the challenges that the region is living currently. As many of you know, 6 months ago, when everyone in the US was concentrated on the elections, Central America was being badly impacted by hurricanes Eta and Iota that blasted the region, leaving their impact in Nicaragua, Honduras, Guatemala, and El Salvador. So I would like to take you to the town of Campur. Campur is a small town of around 1,900 inhabitants. It was, I should say. Most of the population of Campur was indigenous of the Maya Quechua people. This is a small town in the department of Alta Verapaz in northern Guatemala. As a result of the rains that hurricanes Eta and Iota brought to Guatemala, Campur was flooded for 72 days. Slowly, the waters receded in Campur, and nowadays around 75% of the population has returned to that town. What is interesting is that the National Disaster Commission, which is the National Coordination of Disaster Reduction, CONRED is the acronym in Spanish, until now has not produced a report to assess the damage done to the town and the possibility of further flooding and landslides in the town. The town was destroyed by the flooding, as you can imagine. And what we are seeing now is that individuals, with the help of remittances of their family members in the United States, and those who have the means and possibilities to seek loans, are rebuilding in Campur. However, because there is great concern of the possibility of Campur to survive, the possibility of no flooding, electricity has not been reconnected to the town of Campur. They are still waiting that report to assess what possibilities this town has. But this is the situation of a community desperate to continue living where they are, with no state response. Until now, we have seen foreign cooperation. The Japanese government donated resources to Campur. We can see private donors trying to help the community, donating resources, mattresses. Individuals went back, they cleaned, and they are trying to continue with the lives they had. But there is no state ability to assess the damage done and the possibility, as I said, of further risks to the population. The population has even decided to organize themselves. They have a committee that is trying to assess the damage. They have all agreed that if they have a period of over 2 days of continuous rain, they are going to evacuate the town. But this is all self-organizing of a community with no state protection whatsoever. And I think it's important to underscore that in the situation of Central America, they are particularly vulnerable to climate change. It's a very narrow region impacted by both the Pacific and the Atlantic Ocean that is suffering extreme temperatures. Just recently, there was an announcement of the how active the hurricane season is going to be in the Atlantic, and we know that it's going to have an impact on the region. So we have to understand the disproportionate impact of climate change on this weak and vulnerable region for a number of resources, which also has a greenhouse emission of less than 1% of the global house emissions of greenhouses. But nevertheless, they are heavily impacted. So I think that when we're trying to understand the impact of climate change in the region, we have to be able to understand not just factors, but also the impact of climate change in the contextual living conditions of communities, in the vulnerability of their inhabitants, and in the ability of states to respond to these climate events. That's why the situation in the region is so dire, and that's why we observe the flows of individuals trying to seek to enter the United States, which in the current context are finding that the borders are closed, that they are unable to seek any form of protection as a result of the current situation with Title 42. So it's definitely a challenging situation in the region that is only going to increase, because as we're thinking of addressing the root causes of migration, we have to understand that some of those projects are long-term initiatives. We are not going to address the situation immediately, and we have to continue creating policies and solutions that address the needs of the population that is fleeing today. Thank you.
Thank you, Elena. A very important deep dive into some of the dynamics in the region, and that has implications, I think, for all across the world, understanding the context and especially kind of governance issues within different regions. So I'll turn now to Bill, who's our next panelist, to discuss kind of the international context in regards to law, but also for U.S. asylum and immigration law and policy. Thanks, Bill.
Thank you very much for the invitation to speak to the American Bar Association, and looking forward to continuing this discussion and adding to what my colleagues have already presented. What I want to do is to provide a legal framework, an international legal framework for starters, and then to talk about the gaps in protection here in the United States, and end with a proposal for how to try to fix the asylum system here in particular, to make it more accessible to people that are fleeing these threats to their lives and limb as a result of the effects of climate change. It's something called complementary protection, the idea being that you have protection for refugees in the Refugee Convention, but there's a need to complement that with other forms, broader forms of protection. So let me start with, and I'll go to the first slide, this remarkable case from last year that came to the Human Rights Council, which is the supervisory body that interprets the obligations under the International Covenant on Civil and Political Rights. The case involved a family from a small atoll island nation in the Pacific Ocean called Kiribati, which many people may not even be aware of. This was a family in New Zealand that was seeking asylum because they were saying that it was undisputed that within the next 10 to 15 years, the island they were living on is going to be underwater and uninhabitable. And that currently the coconut trees are dying, crops are dying, salinization of the water is occurring, children having diarrhea and other gastrointestinal ailments and diseases. And with the shrinking of available inhabitable land, conflict is growing. So there's violent outbreaks of people that are vying for the remaining land in the country. The decision actually didn't grant asylum to this family, saying that with 10 to 15 years, there was still an opportunity on the part of the the Kiribati government to adapt to this change with trying to do adaptation measures. The The dissenting opinions strongly question that and also talked about the imminent threat and whether a case brought under Article 6 of the International Covenant on Civil and Political Rights, which is the article on the right to life, whether it would require deaths before people could actually get protection on that basis. Next slide, please. So this here, I wanted to refer to the International Covenant on Civil and Political Rights, which the US is a party to. And the three key articles here is Article 6, which we just mentioned, which is the one that, was activated by the Human Rights Committee in saying that the Refugee Convention really was not adequate to address a broad threat to life that's not based on the persecution standard and the refugee definition. We also have Article 7, which is, I think, particularly important to point out in the US context, because American immigration lawyers are familiar with the Convention Against Torture, which prohibits the return of a person to being tortured. But Article 3 of the Convention Against Torture doesn't mention cruel, inhuman, or degrading treatment or punishment. However, this is mentioned in the International Covenant on Civil and Political Rights. And then Article 9 is the right to liberty and security of person. Next slide, please. So let's look a little bit deeper at Article 7, the prohibition on torture, cruel, inhuman, or degrading treatment or punishment. And the Human Rights Committee, the same committee, as I mentioned, that supervises the ICCPR, put forth this comment on the obligations arising from Article 7. And essentially, this is saying that the principle of non-refoulement, the same principle that the US recognizes as an obligation as a party to the Convention Against Torture, applies equally as a mandatory bar on returning someone through extradition, expulsion, refoulement to a place where they would be exposed to cruel, inhuman, or degrading treatment or punishment upon return. This is a huge gap in US law, and this case law has not supported the non-refoulement principle extending to people who would face inhuman or degrading treatment upon return, but it is an obligation, and it's a gap that needs to be addressed and needs to be fixed. Next slide, please. So here's what we are. This is what we've got. We have the refugee definition itself in the Immigration and Nationality Act, which most people are familiar with. A person outside their country who's unable or unwilling to return because of persecution or well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group or political opinion. Now, there's a bit of leeway here. You know, if people are who have been displaced as a result of the effects of climate change are then discriminated against because as previous panelists have mentioned, there's usually multiplicity of drivers of migration. And so climate change can be an aggravating factor here, but put in combination, you can find the elements of discrimination. Also, when you think about the nexus to state protection, the failure of a state to protect someone who may be marginalized, again, through one driver of displacement, through the effects of climate change, and then adding to that these other components as well. But it is a limited definition. It's a difficult definition to reconcile with the broad needs for protection that we often see in the context of climate migration. Next slide, please. So the other mechanism that we have in the United States is also in the Immigration and Nationality Act, the notion of temporary protected status, which I'm happy to report just this past weekend was redesignated for nationals of Haiti, which is certainly very important. And in the redesignation, there's sort of a broader listing of the drivers of displacement for Haitians from what it was originally, which was actually an earthquake. So this has basically three potential bases for protection in the United States. One is ongoing armed conflict, that you cannot return someone safely on that basis. The second one is environmental disaster. And they mention, earthquakes, as I just said, the Haiti one was an earthquake, floods, droughts, epidemics, that, again, make it unsafe for somebody to return. The prong on environmental disaster requires the foreign state to request the designation, which is a complicating factor and one that seems unnecessary. And then the third factor is a bit of a catch-all, which is extraordinary and temporary conditions that prevent people from returning to the state in safety. So there's certainly good potential here. It was prescient of the drafters of TPS to recognize environmental disaster as a driver of migration, and people certainly have been protected. Central Americans in particular, going back to Hurricane Mitch from 1995, have been protected by TPS. But it's a blunt instrument and it's not a very effective one for a number of reasons. The most important reason of which is it's a countrywide designation that applies at the time of the designation for people who are physically present in the United States at that moment. So basically, if you take the Hurricane Mitch example, it protected Nicaraguans and Hondurans that were in the United States before Hurricane Mitch ever hit those countries. It actually did not protect people that were directly displaced by the effects of the hurricane, who may have come and arrived after the designation. So the biggest problem with TPS is that it doesn't protect newly arriving people that are coming to seek protection based on any of these wider grounds of protection, armed conflict, environmental disaster, and other extraordinary and temporary conditions. We don't have a mechanism that allows an asylum seeker to basically use one of these as a grounds for protection. They have to fit into the refugee definition that we saw just in the previous slide. Next, please. Next slide, please. Thank you. So let's look internationally to see what some of the regions have done to recognize the limitations of the 1951 refugee definition and to see if there are ways of expanding that definition. So both in the OAU Convention for Africa in 1969 and the Cartagena Declaration in 1984, each of these regions decided to have an expanded refugee definition. By that, I mean they accept and include as refugees people who have a well-founded fear of being persecuted on the 5 protected grounds. But in addition to that, they also recognize as refugees people who are fleeing broader threats that are not based on persecution or the nexus to those 5 protected grounds. And the key points that I've highlighted here of relevance to the United States, I think, are the notion of events seriously disturbing public order in the OAU Convention and the Cartagena Declaration about threatened by generalized violence or other circumstances which have seriously disturbed public order. These are these 2 frameworks of other circumstances or events, I think are helpful. I think the Cartagena Declaration is somewhat better by talking about circumstances because you can have slow onset, like we saw in the case of the Kiribati family, that wouldn't necessarily be an event like a hurricane or an earthquake. But in both cases, they're talking about serious disturbance of public order as a basis for protection. Next slide, please. In Europe, you have the Qualification Directive, which is binding on all EU member states and is based, again, on qualification for protection under the 1951 Refugee Convention, or what the Europeans call subsidiary protection, which I prefer to call complementary protection. but it has the same meaning. And in this, they list 3 grounds for what they recognize as serious harm that a person might face. The first that they recognize, of course, which is we've come along, we're still a ways away from here in the United States, is the death penalty or execution. I'll put that aside for the moment. The other is torture, inhuman or degrading treatment or punishment, which they recognize as treaty obligations under the Convention Against Torture and the ICCPR. And then the third one is indiscriminate violence in situations of international armed conflict where there's a serious or individual threat to a person's life. You'll note here that there isn't a specific reference to climate as a basis for subsidiary protection. So I would say that's a gap in the EU qualification directive. But nevertheless, I think it's important to see the recognition of the principles, both stemming from the ICCPR and also the broader notions of indiscriminate violence. Next slide, please. So here's the proposal that I would be making, or that Human Rights Watch would actually be making to the US government to propose a complementary protection definition for the United States. This would be, in practice, it would be a standard that would be applied in a single interview or hearing by a USCIS asylum officer or an immigration judge. So it wouldn't be a separate hearing. It would be a standard that would be applied. First, you would apply the Refugee Convention standard, the INA definition for asylum in Section 208 of a well-founded fear of persecution on the 5 protected grounds. But then you would apply this standard as well for people who don't meet the 51 Convention standard. And what we're suggesting is that it would be for people who face a serious threat to life or physical integrity if returned because of a real risk of cruel, inhuman, or degrading treatment or punishment, violence, or exceptional situations such as natural or human-made disasters, including from the effects of climate change, for which there is no adequate domestic remedy. So let me, in the time remaining, I want to go through the key points of this definition. Next slide, please. So first, it applies to people who are outside their country. So it's a principle of non-refoulement. It's not returning people to face this situation. It's forward-looking. It doesn't require a showing of past persecution. It's someone who would face this serious threat. But it also doesn't want to undermine the protections of the 1951 Refugee Convention by saying that you first need to assess whether a person meets the Refugee Convention standard. And also the person is outside their country. So it doesn't apply to internally displaced people, which we've already established. Most of the people displaced by climate change will be internally displaced. The second element are that the person faces a serious threat to life or physical integrity if returned because of a real risk. Now, there are a number of different elements here. Serious threat gets to the notion of seriousness. When you think of the persecution threat, that's a serious threat in the refugee context. In the qualification directive in the European Union, they're talking about serious harms. And then those are the 3 notions of serious harm that flow from that. And we're talking here about a serious threat to life. That's Article 6 of the International Covenant on Civil and Political Rights, the article that was addressed in the Kiribati decision, or physical integrity, which is Article 9 of the International Covenant on Civil and Political Rights. They say security of person in the ICCPR. I prefer physical integrity, which is the terminology that's used in the American Convention on Human Rights. It's also the terminology that the UN High Commissioner for Refugees uses in its expanded mandate on refugee protection. If returned, again, is the notion of refoulement, that this is about, this is not about resettlement. It's not a criteria for admissions. It's a refoulement standard. It's to prevent people from being returned to face these serious threats. And then finally, a real risk, which also comes from the terminology of Article 15 of the Qualification Directive. And I want to make the distinction between the serious threat and the real risk. So the the real risk is the probability that something will happen. Is this likely to happen? Is it a possibility? Is it more likely than not? So this is establishing the likelihood of an event happening or the risk happening. It's not about the seriousness of the risk. So we have, on the one hand, a serious harm that's being threatened to life or physical integrity. And then secondly, there's a real risk of that serious harm occurring. Next slide, please. So here, explicitly, I think what we need is a reminder to US decision makers that they are mandated not only under the Convention Against Torture, but also under the ICCPR, not to return people to face cruel, inhuman, or degrading treatment or punishment. And I think this is a notion that can be applied broadly when you look at inhuman and degrading treatment conditions, oftentimes conditions of detention that people are exposed to upon return to various countries, but also to environmental conditions that would be inhuman and degrading. Next, violence. You notice if you think back to the qualification directive and to the TPS standard, there are references to armed conflict in the temporary protected status statute. It's ongoing armed conflict. In the qualification directive, it's armed conflict arising out of international armed conflict, generalized violence out of international armed conflict. My suggestion is to drop the armed conflict nexus. I don't think it's necessary here. I don't think it's relevant here. Certainly armed conflict would be inclusive, but if it's a serious threat to someone's life and it's a real risk, then I'm thinking particularly in the Central American context of women who are fleeing domestic violence, for example. And gang violence would again be captured by this, whether or not that qualifies as armed conflict. I think this would make it very clear to decision makers that people fleeing gang violence or fleeing domestic violence should also be protected. And on human rights grounds, there's no reason not to protect people on the basis of a real risk of a serious threat of violence, serious threat to their life or physical integrity. Next. And then finally, we're looking at exceptional situations such as natural or human-made disasters, including from the effects of climate change, for which there's no adequate domestic remedy. Again, I could break down each of these points, but we looked at the OAU Convention and the Cartagena Declaration earlier, which talked about circumstances and events seriously disturbing public order. Again, to me, the public order notion is a step removed from a threat to a person. That's a threat to order. What we want to be looking at is, again, the threats to life and physical integrity, and let's look at the exceptional circumstances that feed into that. So we're not talking about normal circumstances. So poverty, for example, which is certainly a driver of migration, would not be recognized as a basis for complementary protection under this standard. But we are specifically mentioning here, and it is a dependent clause, so it's not necessary to the definition, but we're providing as an example, such as natural or human-made disasters, including from the effects of climate change. So we wanted to capture, and I think it's important to capture explicitly that we are thinking about the effects of climate change here. And so that again, decision makers, when they are dealing with a person who's talking about their crops having failed, a famine perhaps looming in the horizon for them, rising sea levels, desertification, all these environmental drivers, including slow onset drivers, that this would be taken into account as a basis potentially to protect people. And then finally, the notion of the adequacy of a domestic remedy. And I think this is also very important to understand that there may well be internal protection alternatives or internal flight alternatives for people that are fleeing localized environmental disasters. There may be, rising sea levels would have the enormous effects in displacing people in low-lying areas, but they may have the opportunity to relocate to higher areas. Or there may be other remedies, humanitarian interventions, and so on, that could be used. And so you want to look at that. But also, we're talking about the adequacy of those domestic remedies. Are they realistic remedies? Are they relevant remedies for the threats that somebody would face? And so I think this would be worked out in case law, but I think as a basis for bringing the United States, which currently is pretty much an outlier. If you look at the entire European Union, you look at Africa, you look at Latin America, they all have complementary protection. Many other states, Australia and others, have various pieces of complementary protection in their refugee and asylum law. The United States really doesn't have this. And TPS, while it is the instrument that we have, and it's the one that we continue to use, is not an instrument that helps people upon arrival when they're seeking asylum. And so I think that needs to be addressed, while at the same time we continue to address the many myriad other issues that need to be addressed in order to make the US asylum system fair and responsive to people that are fleeing not just persecution, but more generalized threats to their life and physical integrity. And with that, I just want to add a final slide for people who would like to learn more about this proposal. I've done a journal article in the Journal of Migration and Human Security, which goes into it in quite some length to go through it point by point. But also 2 op-ed pieces that sort of talk about this contextually in terms of both the US asylum system, but also globally in terms of the Kiribati decision and making sure that the US is compliant with the evolving standards of international law that are recognizing climate-induced displacement as a basis for protection. Thank you.
Thank you, Bill. Compelling avenue or pathway forward, and it's already inciting much discussion in the Q&A. So I figure I'll go ahead and turn directly to some of those Q&A questions. First, there's a couple that trickled in not over the Q&A, and I just want to pose that to you first. One is, what can organizations that serve recently arrived asylum seekers do to help further protections for people displaced due to climate change when there is no current legal remedy for them? Bill, maybe you want to take, and actually maybe we'll take a bunch of questions, because actually I see now we have 9 minutes left.
Yeah, I mean, that's a very important one. And in some degree, it's trying to fit, a square peg into a round hole or whatever. I mean, what we have is the current asylum definition. So within the scope of membership in a particular social group, or looking at, again, some form of discrimination that would also adhere to people who have been displaced as a result of climate. As Kaylee, I think, mentioned at the outset, it's, disproportionately, it hits poor people, it hits marginalized communities. So look at this as an aggravating circumstance, but try to link it to one of the more recognizable grounds in current asylum law.
Yeah, and UNHCR's October 2020 legal considerations paper on this might be useful in that regard. So I'll just go ahead and link that in the chat box. There's some follow-up as well to your proposal, Bill, about would this proposed new definition require congressional action? And if so, what is the likelihood that it would happen given the current Congress?
Yes, is the question. I think it does need a statutory change. It's it's a fundamental. It will be a fundamental reworking of the U.S. Asylum system. But I think we're ripe for such a change. I mean, the comprehensive immigration reform has been on the table for quite a number of years. There hasn't been a major overhaul of the asylum system since the 1996 Illegal Immigration Reform and Control Act. Which of course was a step in the wrong direction, basically, introducing expedited removal and other disasters. As I argued in a piece that appeared this week in The Hill, we have an enormous backlog in the immigration courts now, over 1 million cases. And part of what I'm suggesting here is that this is a more expedient and a more efficient way of moving cases quickly and getting through the backlog. And so rather than tweaking the procedures, if you change the standard and you create a broader standard, you're going to be able to get through cases, you'll get through the backlog, you'll keep current with current applications. And Germany shows this. I mean, in 2015, they had 890,000 people, new applicants for asylum. And within 2 years, they had they were current with new applications. There was no backlog whatsoever because they applied the subsidiary protection standard as well as the Refugee Convention standard in one interview. The likelihood of it, that's another question.
And I think there's two, as lawyers would put in the chat, two quibbles about language within your proposal, Bill, and I'll lump them together, one from Daniel Baker, who or which entity would determine the availability of an adequate domestic remedy. That section seems right for exploitation. Another asks, when there is an increasing acceptance that disasters are not natural, but arise from natural hazards interacting with existing exposure and vulnerabilities, is there a need to use the modification natural or human-made before disaster? You're on mute, Bill.
So I was trying to be so good about muting myself and then I didn't unmute. I'm not sure I picked up all the details on the second question. On the first
essentially that question is, do we need to say natural or human-made before disaster, as disasters are not natural?
No, I mean, a disaster is either natural or human-made. So yes, you could knock that out, but I wanted to ensure that both kinds of disasters would be contemplated. So whether you think of a Chernobyl, as clearly a human-made disaster, and of course you get into the question of what are the causes of climate change. So perhaps avoiding that entirely. Politically, there may be some merit in doing that. On the first question, which now that was the one I'd remembered. Now I've forgotten already. What was that?
Sorry, Bill, I'll pull it up again, which is who or which entity would determine
on adequate.
Adequate, yeah.
Yeah, I mean, good, very good question. And I'm aware myself that this is not a word that has been adjudicated, and so it would require judges, case law, basically, to determine what is an adequate domestic remedy. It somewhat is akin to the standards that are applied with internal flight alternatives and internal protection alternatives, which again haven't been particularly adjudicated in the United States, but there's been a lot of international jurisprudence on what constitutes an internal flight alternative. And so I think that might be applicable here as well. But we included the word adequate here because we actually wanted to provide, we didn't want to suggest that any domestic remedy was sufficient, that it did have to be adequate to make sure that someone was protected. And so, I think it's an important concept to include, but how it gets interpreted, would be up to case law, to specific cases to see.
And I think there's a couple other questions before we wrap up, and I'll lump them together and I'll let Bill or Elena address them. One is, when considering TPS as a protection mechanism, how do you get around the requirement in the environmental disaster subsection that the situation be temporary? And the other one is, what can local governments in the US do to support climate migrants?
I would like to try to answer that. I think that it's definitely a challenge. And what we have seen is that even though intended to be temporary, TPS has been extended for a number of years. And that's because of the state inability to improve the situation on the ground. And so individuals are unable to return after a number of years. And so a situation that ideally was temporary has become a permanent one. The problem is that individuals have been in this temporary situation for 20 years. And what we now are faced with is the need to create a path for these individuals in a temporary situation towards permanent residence in the United States. And I think that is very much connected to the prior discussion about an adequate response or not, because in some cases, countries may have on paper a great response, but they may lack the resources and the ability to implement those responses in practice. And so again, as we have in asylum with the category of social group, experts who can document and explain the situation on the ground become very relevant in the determination of this specific form of protections for specific groups of individuals. Thank you.
Yeah, and just one further point to add, which is I think the credibility of TPS is undermined by the notion of temporariness, because in fact it hasn't proven to be temporary in most cases. That we have protracted situations and protracted effects of a climate event that still make it impossible for people to return. And it's also a very politicized process as well. So I think having something that would apply within a legal framework to individuals would certainly be much more supple. The other question that I think that this raises is the question of the benefits that apply to the status that you achieve. So temporary protected status has minimal benefits, basically. It's supposed to be temporary. You're not supposed to be able to adjust your status as a result of that. Whereas asylum, you're adjusting to lawful permanent residency and you're on a path to citizenship. The proposal that I'm suggesting for complementary protection, essentially what I would propose is the same benefits to a person who has been recognized as needing to be protected on complementary protection grounds as somebody that's protected on the basis of a well-founded fear of being persecuted. So I wouldn't make any distinction. I would allow people to, they would maintain that status for a year or so and then be able to adjust to lawful permanent residency.
Thanks, Bill. So we've reached the hour, the top of the hour. I want to thank the American Bar Association for putting this together. I'm sure it's a first in a series of conversations that will touch on this challenging issue that will become more and more relevant with time. I want to thank Elena Lea for joining us and Bill Freilich for joining us, for giving us some context and greater understanding about the issues on the ground, as well as for providing us possible pathways forward. And I hope we can continue to be as progressive and push as much as we possibly can on these issues. And I look forward to working with you both in the near future. Thank you all for joining us.